Welcome to This Explainer. Today, we're diving into a really fascinating piece of legal history where a massive constitutional showdown didn't revolve around some grand, sweeping ideology. Nope, it revolved around one tiny, everyday word. We're going to explore a landmark case from the Constitutional Court of South Africa, the South African Police Service versus the Public Servants Association, just to see how a simple, three-letter word managed to bring an entire national police restructuring process to a grinding halt. So let's get right into it. The word may. In our normal everyday lives, it's just a simple semantic tool, right? It expresses possibility or permission. You may go to the park. It suggests you have a choice. But, well, in the world of law, may can be a total paradox. Sure, it can mean you have the permission to do something if you choose to, but in certain contexts, it can actually mean you have a strict, absolute duty to do it. So, it really all boils down to this one crucial question. Does may mean you have a choice, or does it mean you must do something? Keep this question in the back of your mind, because it's exactly this linguistic ambiguity that triggered a multi-year legal battle between the National Police Commissioner of South Africa and the police unions, a battle that climbed all the way to the highest court in the land.
Section 1. The word that caused war. To understand how things escalated so quickly, we need to unpack the specific regulation that started this whole mess.
Here it is in black and white, SAPS Regulation 24-6. This was promulgated back in 2000, and it reads, if the National Commissioner raises the salary of a post, she or he may continue to employ the incumbent employee in the higher graded post without advertising the post, provided, of course, that they're doing a good job. Now, the commissioner looked at this and thought, great, I have the discretion to keep the current person without advertising, but I don't have to. The police unions, though, they looked at that exact same sentence and said, no way. If they're doing a good job, you must keep them without advertising. Literally, this single sentence caused an absolute gridlock. Section 2, restructuring the police service. So why were they fighting over job upgrades in the first place? Let's zoom out a bit to look at the historical context. Back in 1994, South Africa democratized. The pre-1994 police force used to promote people in what were called blocks, based mostly on seniority, basically just what year you joined. Well, that had to end. The nation needed to amalgamate a bunch of different agencies into a new, unified South African police service. They were aiming for demographic representation, equal pay for equal work, and an entirely new job evaluation system. By 2000, these new regulations were finally rolled out, but by 2001, this massive restructuring effort hit a total breaking point. To give you a sense of the sheer scale here, 1,333. During that 2000 to 2001 period, that is the number of vacant superintendent posts that needed filling. And many of these were just upgraded captain posts. The commissioner decided to advertise all of them to ensure complete transparency, but this meant that a lot of captains who were already sitting there doing the job didn't get promoted into their own newly upgraded posts. As you can imagine, this sparked massive grievances, leading to incredibly expensive and time-consuming arbitrations. And then the system just broke. Shortly after that superintendent issue, 3,356 vacant captain posts suddenly needed to be filled. Because of the previous nightmare, the commissioner basically said, stop, and suspended filling upgraded posts entirely. The whole administrative apparatus of the National Police Force was paralyzed just by the volume of disputes over how to fill an upgraded job. Section 3. Efficiency versus job security. Now, this wasn't just some petty squabble over bureaucracy. This was a fundamental collision between two highly valid, incredibly important imperatives.
Here's why this case is so gripping. The commissioner argued that he has a constitutional mandate to manage the police force efficiently, right? He needs discretion. Automatically promoting people without advertising lacks transparency and definitely doesn't guarantee that the best person gets the job. But the union countered with a really strong point. If an employee is doing a stellar job and management decides to upgrade the post, forcing that same employee to re-interview against outsiders and potentially lose their job if they aren't chosen is manifestly unfair. It's an unfair labor practice. Honestly, both sides make excellent points here. So the courts were handed this highly complex puzzle. They had to weigh the commissioner's constitutional mandate to control the police against the constitutional right of every single employee to fair labor practices, all while factoring in the overarching goal of equality and representativity within a transforming society. It's a lot to balance. Section 4. The lower courts disagree. So what happens when two rock-solid arguments collide? You get judicial ping-pong. Let's see how the lower courts handled this one.
The dispute started climbing the judicial ladder. It kicked off in the Pretoria High Court, got appealed to the Supreme Court of Appeal, and eventually landed right at the Constitutional Court. And at every single step, the judges strongly disagreed with one another. First up, the Pretoria High Court ruled in 2003. They firmly backed the commissioner. The court stated that the word may is completely unambiguous. It grants clear discretion. The judge really emphasized that there's a powerful public interest in having an efficient police service, and elevating officers without transparent advertising goes entirely against that. So at this stage, it looked like a clear victory for management flexibility. But then, the unions appealed to the Supreme Court of Appeal, and wow, we saw a dramatic pendulum swing. The court was heavily divided in a 3-2 split. The majority ruled in favor of the unions, totally overturning the High Court, while the 2 dissenting judges agreed with the High Court's original take. For the Supreme Court of Appeals majority, the crucial point was the severe real-world consequence of the High Court's ruling. Their logic went like this. If the commissioner has discretion to advertise the post, someone else might get it. And if someone else gets it, the current incumbent, who is performing perfectly well, would essentially lose their job simply because the job was upgraded. The majority ruled that the drafters of the regulation could never have intended such a drastic, unfair result. Therefore, in this specific context, may actually meant must. The commissioner had a duty to promote. Section 5, the Constitutional Compromise. With the lower courts completely at odds, the Constitutional Court finally stepped in. And what they did next is an absolute masterclass in legal interpretation. Justice Albie Sachs, writing for the majority in the Constitutional Court, utilized a pretty brilliant approach. He relied on an older principle, stating, "The judicial function is to balance out and reconcile the opposed claims in as just a manner as possible." He didn't want a winner-takes-all scenario. He recognized that both state efficiency and job security were vital, constitutional demands. They shouldn't cancel each other out. They needed to be harmonized. So here are the exact harmonizing steps the Constitutional Court took. Step 1. They agreed with the commissioner and the High Court. Grammatically and contextually, may absolutely gives the commissioner the flexibility and discretion to advertise. He's not forced to mechanically promote people. But step 2. They also agreed with the union's underlying fear. You cannot use that discretion to cause a redundancy. So they built in a clever safeguard. Section 6, the final verdict. How did the Constitutional Court practically solve the paradox of the word may? Let's look at the final rules. Here is the true Goldilocks resolution of the judgment. First, may does not mean must. The commissioner has the absolute discretion to advertise an upgraded post to ensure transparency and efficiency. There's no automatic promotion. However, and this is the genius caveat, that discretion cannot result in the retrenchment or job loss of a satisfactory incumbent. The commissioner can advertise for sure, but only if he ensures the current worker isn't just thrown out on the street because their job got a pay bump. The state gets its flexibility and the worker gets their security. Which leaves us with this final thought to chew on. A single 3-letter word, may, caused years of litigation, impacted thousands of police officers, and required the sharpest legal minds in the country to find a balance between state efficiency and human fairness. So next time you're reading a contract, a workplace policy, or even just a simple set of rules, ask yourself, what is the true cost of a single word? Thank you for joining me on this explainer. I really hope it sparked your curiosity as much as it did mine. Keep learning, and I'll see you next time.